Armed Forces Court Martial Amendment Number 2 Rules 2024.
Will the Minister to move the motion?
I beg to move.
It's a great honour to be under your chairmanship today, so thank you very much. I beg to move that the draft Armed Forces Court Martial Amendment Number 2 Rules 2024 be approved. The statutory instrument before us today amends the 2009 Court Martial Rules by changing the rank requirements for the President of the Court Martial Board, where the defendant is a very senior officer. Before I set out the changes the statutory instrument will make, it may be useful to the committee for me to provide some context regarding the role of the Court Martial Board within the service justice system. The UK's separate system of military justice dates back to the Bill of Rights in 1689. Having a separate service justice system enables a comprehensive system of command and discipline on which operational effectiveness is based to be enforced swiftly and efficiently. The service justice system reflects the need to maintain discipline through sentences, which can be imposed by the commanding officer at summary hearings or in the court-martial for more serious offences. The consistency of the court-martial for trial proceedings comprises of the judge advocate and a board of lay members. Depending on the offence or the offences being tried, the board will consist of three to six lay members. Their role is similar but not identical to that of a jury in the Crown Court in England and Wales, as they're solely responsible for deciding the guilt or the innocence of a defendant at a contested trial proceedings, based on the evidence that is presented to them. The constituents of a court-martial board depends on whether the defendant is a service person or a civilian, and when some or all of the members of the court-martial board are service personnel, the president of the board is the senior officer. The role of the president includes that of a foreperson of a jury. They will chair the discussion during deliberations on the verdict and will ensure that all members have an equal voice and vote. An overriding principle is that the constituents of the court should be fair, which lay members drawn at random from the widest potential pool. And this is crucial because it includes a deconfliction process to identify if any member knows another member, a defendant, or indeed a witness, whether they have served in the same unit as the defendant since the date of the alleged offence. Now, there's been a recent case highlighted where there's a risk to the overriding principle of fairness. The Court Administration Unit initially encountered difficulties in finding a president at a board to try a case where the defendant was a senior officer or a major general. As a senior officer, he was well known, he was connected to the system, he'd gone through the same career courses as many of those who were trying to or were to be put onto the board, and his potential character witnesses included serving and retired OF9s, so all the way to the senior levels of the military, and they were known to a pool of potential board members. It was exceptionally difficult to find and select that board/jury. So by the time of the trial, however, the defendant had left the army, so the use of civilian members of the board was permitted, but nevertheless, this would not have been possible in law had the defendant still been serving. While cases involving defendants who are senior officers is rare in the UK, it is sensible for the service justice system to be ready and able to deal with these cases, close this loophole if and when they occur. So this statutory instrument addresses this issue by amending Rule 34 of the 2009 Court Martial Rules, which sets out the requirement for the President of the Board. Currently, Rule 34 requires that the defendant is a rank of OF6, so a Brigadier or above, that's a Commodore, Brigadier or Air Commodore, and the President of the Board must be a superior rank to that of the defendant. This can include the President holding the same rank as the defendant if the President is more senior to the defendant with the rank. The statutory instrument before us changes this requirement. Where possible, the President of the Board will always be the highest appropriate officer available. However, to close a loophole, if it is too difficult to find an officer of superior rank due to a lack of impartiality in particular, or availability, this change allows the military to broaden the pool of potential presidents. In the rarest of occasions where the defendant in the rank is of OF6 or above, so that Brigadier or above, we will prevent a conflict of interest by selecting a suitably qualified but completely disconnected officer with a minimum rank of OF6. This will allow them to impartially act as the President of the Board, chair the discussions during deliberations on the verdict, and ensure that all members have an equal voice and vote. Importantly, no conflict of interest will be identified. Every effort will still be made to find the most senior ranking and impartial President of the Board, but while only likely to be used in exceptional circumstances, this amendment ensures that where the defendant in a court-martial is a very senior officer, it will always be possible to select a President of the Board with the appropriate seniority for the important duties and functions of the role, eliminating the risk of a legal case being overturned. I believe Armed Forces personnel should all be held to the highest possible standards. No one should be able to time the system out, whether they are starting out or at the end of their military careers. And I believe in the fairness and rigour of our service justice system. No individual, irrespective of rank, should get off on a technicality. A high-functional service justice system underpins the operational effectiveness of our armed forces. I beg to move.
The question is that the committee has considered the draft Armed Forces Court Martial Amendment Number 2, Rules 2024. Chair Minister.
Good morning, Mr. Efford. May I say it's a pleasure to serve under your chairmanship this morning. As we debate the Armed Forces Court Martial Amendment Rules 2024. Incidentally, Mr. Efford, when I served as a Minister of State for the Armed Forces about a decade or so ago now, I attended part of a court-martial during a ministerial visit to 16 Air Assault Brigade at Merville Barracks in Colchester. There's a court-martial centre there, and I witnessed part of a case and had the opportunity to observe the system in action firsthand for myself. Looking at the order before us this morning, it seems to me to be relatively straightforward. However, I do have just 3 specific questions for the Minister today. Firstly, I note in the accompanying explanatory notes at point 2.1, it says that, and I quote, Dr. Andrew Murison, the Parliamentary Under-Secretary of State for Defence, People and Service Families, confirms that this explanatory memorandum meets the required standard. I raise this point because it suggests that the order itself was approved by the Right Honourable Member for South West Wiltshire when he served as a minister in that capacity under the previous government. If that's correct, perhaps this minister could explain to the committee how long the order has been in gestation, as the implication is that it appears to date back for quite some time. Secondly, if I read the order correctly, it seems to relate partly to sentencing provisions as well as the conduct of court-martials themselves. And the Minister didn't really say much about that in his remarks, so I wonder if he could confirm if my understanding of that is correct. Thirdly, if the order's passed this morning, which I rather suspect it will be, Mr. Efford, as we are debating the Armed Forces Court-Martial Amendment Rules 2024, and unless I'm mistaken it's now 2025, perhaps the Minister could give us some idea of when this order would actually come into practical effect.
Paul Foster.
Thank you. I'll be brief, thank you, Chair. I was wondering if the Minister could just confirm that this is generally just closing an existing loophole within the current legislation. And additionally, what it will allow is to speed up the whole process of court-martials, and ultimately that has got to be in the best interests of everyone involved. Thank you, Chair.
Minister.
Thank you. First of all, to address the Honourable Friend's point, my view is that this is addressing a loophole that has allowed, not nefariously, but potential senior officers to time the system out because of our inability to select what we would call a military jury. By broadening this out, it really speeds it up and indeed will bring people to justice in the fastest, most effective and most efficient way. To address some of the questions from the Honourable Member, from my perspective, the previous Minister under the Conservative government pushed this in 2023. There obviously has taken time within the bureaucracy of defence to pull this through. It was raised to my awareness when I sat down with the service justice system, and I agreed it almost immediately because it made complete sense. So I think we have sort of cross-party agreements on that. From a sentencing condition perspective, this is primarily about the makeup of the board. It doesn't affect the sentencing as a whole. That system will stay in place. And then what I would say, how long it's, from my perspective, whether it's linked into the Armed Forces, broader legislation, that will come out in the Armed Forces Bill in the next 12 to 24 months, where we'll have a far greater opportunity to ensure that the correct legislation is in place to enable us from everything from recruitment and retention all the way through to improvements into the service justice system as a whole. I'm really broadly, I'm grateful for the contributions from my honourable friend and from the other side, but I would like to close out, if possible. In the rarest of occasions, and where the service justice system is investigating a senior military person, it proves difficult to find suitably disconnected and impartial senior officers. I personally believe that this change will ensure that we open the aperture to select and allocate senior officers to deliver the service justice in a timely and effective manner, maintaining the integrity and fairness of the service justice system, and in doing so, maintaining the operational effectiveness of our armed forces. I commend this instrument to the committee.
The question is that the committee has considered the draft Armed Forces Court Martial Amendment Number 2 Rules 2024. As many as are of that opinion say aye. Aye. Contrary no. The ayes have it. The ayes have it. Order. Order.